total 46 petitions on the caption petition, as well as others who have not filed any such petitions. Whosoever comes in order of merit in the same merit list may be given recruitment to the post of so and so.
Yes.
This is what Lord Ka.
Yes.
So far as that is concerned, that would make the interim relief which was granted to the petitioner at the stage of admission, because when we filed a petition, the merit list were not published. There was a specific direction given.
Which part? That part with regard to persons
40
beyond the petitioner.
beyond the petition.
Right.
So far as if they are doing it, means they have subsequently issued the advertisements also, which is subject matter of challenge in some another petitions too. Herein, where the statutory norms which are not considered. And prior thereto, merits when we have approached this honorable court and has secured the interim orders in our favor, months, they did not respected the orders of this.
Very well. So there are Mr. Gautam, I understand. Two issues, two things which are being said. One, 819 candidates who have applied with benchmark disabilities, of which the state will first consider whether any of them would independently come in the merit list. They will be adjusted for the means in the merit list, and thereafter whosoever is remaining, they will be looked into as per their merit for appointment. Now the only part with regard to who have not filed any other petitions. Right. Mr. Advocate General, while I understand the concern of the state, but why would you say that somebody who is before this court from the year 2021 and should be what do you say, should be in the same?
I quite see.
Yeah.
Only worry, my lord, is tomorrow those people may come forward. Why should they not be given the same benefit?
No. They for some, the entire issue with regard to the non-appointment is kept alive by way of these petitions.
Okay.
If these petitions were not there, you would have this entire exercise would have been done and dusted with. It would have been over.
I have followed it.
Right. So if what the formula could be that if in the order of merit after the petitioners are considered and if there are any vacancies remaining, then you could consider cases of persons. It is for the state to take an independent decision for people who have not approached the court. But somebody, if this were something in 24-25, what you would have said may have been correct, but the entire issue is kept alive by the petitioners for last 4 years, and then at the end, when they have to reap the benefits, you say that no, everybody stands on equal footing, may not be very. Yes.
Instructions below. Then I need some kind of observations for
Very well. Fine. So this is your proposal.
Lodge.
I'll record your proposal.
Lodge.
And I'll deal with your this part also. Right?
And we will be permitted to adjust this, my lord, because ultimately, my lord, in a PIL, we had come out with, my lord, the number of vacant posts to be filled in. So we had conducted a special drive last 3 lines.
Right. No, adjusted fine. Adjusted subject to appropriate orders by the Honorable Division Bench, because I cannot advise the Honorable Division Bench. Right.
This we are doing it.
Right. So I'll say that since these 248 candidates would. All right. Okay. Fine. So I am not touching 8. I am not touching 8. I am only 1 to 7. I'll say that this is the proposal that has been received, and I'll deal with 7. Heard learned advocate Mr. Swapneshwar Gautam and learned advocate Mr. K.B. Pujara on behalf of the petitioners. Learned Advocate General Mr. Kamal Trivedi with learned AGP Miss Aditya Pathak. Yes, for respondent state. Pursuant to submissions made, on previous occasions, learned government pleader has submitted a brief note by the state, with more particularly in the nature of a proposal. The proposal being, the stand of the state being that as per the requirements of the Rights of Persons with Disabilities Act, 2016, the state is required to appoint not less than 4% of appoint candidates to not less than 4% of the total number of vacant posts, comma, in each 1% in each category for persons with disabilities referred to in clauses A, B, C, D, and E of section 34 into bracket 1 bracket over of the Act, full stop. It is submitted by the state that considering that 2736 posts in secondary schools and 3452 posts in higher secondary schools were advertised, comma, 4% of which would in total come to 110 and 138 posts, comma, the total being 248 posts are required to be reserved for candidates with benchmark disabilities. It is further informed by the state that a total of 621 candidates with benchmark disabilities had applied for selection for in the 2736 posts for teachers in secondary schools, and a total of 270 candidates had with benchmark disabilities had applied in with regard to the 3452 posts of teachers in higher secondary schools, full stop. The state has indicated its inclination to call the 891 candidates with the benchmark disabilities, i.e. 621 plus 270 as above, comma, for document verification, and thereafter prepare merit list for the 248 posts, full stop. Mr. Advocate General, one more question. What if one of these candidates is so meritorious that he or she may be entitled to be placed in the merit list of her own accord? You have not conducted document verification of these 891 candidates, right? What if one of the candidates is so meritorious that he or she may be entitled to be placed in the general category or merit category of her own accord without giving her the benefit of this act? Then what happens?
It is entitled.
Right, fine.
My only anxiety is, while doing this, it may so happen that merit is compromised. Out of 46 petitioners, let's say there are 10 people who are not meritorious at all.
Right. Then you see, if you have your cutoff, you have a cutoff.
No, this is the 248 posts.
You have your cutoff of in the sense that when you are doing document verification, how will you assess merits?
As per the norms, qualification and TET.
Right.
TET marks.
Right. So TET marks. So if they don't fall within your benchmark criteria, then you have all the right to say no to them.
That will be also.
No, first
So there would be any benchmark because it has to go by the merit.
Right.
Weightage is given for basic qualification of graduation,
Right.
then B.Ed
Right.
and TAT.
Right.
So 30%, 70% is the weightage given to both the qualification.
Right.
According to which merit would be worked out of each candidate. There would be a merit list accordingly.
Right.
For all number of seats.
No, I didn't get you. Come again, please.
All candidate, the merit is to be worked out on the basis of educational qualification for which 30% is the weightage. 70% weightage is given to the TAT examination.
Right.
The requirement so far as secondary is concerned, graduation plus B.Ed plus TAT. So far as higher secondary is concerned, post-graduation, B.Ed plus TAT.
Right.
Weightage remains the same, 30%, 70%.
Very low. But then, are they not required to, is there no benchmark criteria?
There is no further criteria because TAT itself there is a mark.
So then I don't
less than those who have less than 70, 60 are not eligible at all.
So I don't need to say, I only see that out of the 891 candidates, they may be as per the petitioner's case may be first considered as per their merit, and if there are any vacancies remaining, that can be considered.
Vacancies would remain. There are 248 posts.
Right. So the rest of the
If I
vacancy,
accommodate 46 straight away.
Even then 202 are there.
202
For
you can
others.
accommodate for others, but first will be 40.
My
I'll take care.
Compromising merit aspects so far as those 46
Naturally,
positions are
naturally.
concerned. And
Those 202 people will now be entitled for appointment because these 42 were there.
I quite see that.
So then
We are in the period of merit.
All
law.
right, merit is fine,
So-
but then they cannot have their cake and eat it too.
They can't
Yes.
say that merely because we filed the petition,
No,
that it
but-
should be compromised.
You had all the right to say that 202 posts you will take it in the what do you say, that will be adjusted against the remaining this.
Then I'm just making a statement because this whole exercise is being undertaken now.
Huh.
Earlier we were not following this.
Right,
Therefore, whatever we do today, that should get adjusted.
right.
Supposing tomorrow we will.
So
not-
it'll be a case of few stray case here or there, not much.
46.
Right.
Out of 46, say for example, only 10 are meritorious
But then-
as compared to others.
Right, but then we have a certain dislike for fence sitters.
So I-
We in the sense the judicial process has a dislike for.
further litigation. So that all are being.
I'll take
So far as my lord's this is a horizontal reservation.
Hmm.
So that will not go over there.
Right. So that I understood that. Fine. All right. Where were we? For document verification and prepare a merit list. Full stop. A strong objection has been raised by learned advocates for the petitioners in this regard, inasmuch as according to the learned advocates for the petitioners, while the state may or may not fill up the entire 248 posts, yet it is submitted that the state, having accepted the right of persons with disability to be entitled for reservation as per the RPD Act, is on account of the petitioners having approached this court by way of this petition. It is submitted that since the petitioners have been fighting from the year 2021 for the reservation, precedence should be given to the petitioners at the time of appointment, and whereas as far as the remaining 204 posts are 6 posts are 240
We have 46.
46 remaining 202 posts are concerned, the state may exercise its discretion as regards the same. Full stop. While learned advocate general would try and submit that all the petitioners may not score high in the merits, and probably in accepting the submission on behalf of the petitioners, merit may have to be compromised, yet, to this court, it would appear that the submission made on behalf of the learned advocates for the petitioners require consideration. To this court, it would appear that it is only on account of the petitioners having approached this court in the year 2021 that after 4 years the state has agreed to implement the provisions of the RPD Act as regards the said selection process. Full stop. The petitioners having approached this court and having stood up for their rights, to this court it would appear that the petitioners should receive a precedence at the stage of appointment, and whereas insofar as the remaining 202 posts are concerned, the state may either appoint candidates from the list of 891 minus 46 into bracket the petitioners, or the state could adjust those 202 vacancies in the recruitment drive which they are conducting as per the direction of the Honorable Division Bench dated
You did not say that because you would like to adjust the whole.
right. I'm saying it's your discretion
Right.
to adjust in what was that?
Because I would like to adjust entire 240.
I understand. I am saying it's your discretion then.
Right.
After petitioners, whatever you do, it's your.
That aspect may be left open.
So I'm saying discretion. It's whatever you do, it's your discretion. Yes. Or the state could take the 202 remaining posts for state could consider recruiting candidates in the 202 posts in the recruitment drive being conducted pursuant to direction of division bench of this court in writ petition into bracket PIL number 46 of 2023. Full stop. Having regard to the above observations, the following directions are passed. 1. The state is, as per their proposal, permitted to fill up the 248 posts, comma, which would be considered as reserved for persons with benchmark disabilities under the RPD Act 2016. Full stop. The state at the first instance shall conduct document verification of 46 petitioners, in all 46 petitioners, and appointment orders shall be issued to the 46 persons at the first instance. Full stop. Next. The state would be at liberty to fill up the remaining 202 vacancies out of the 891 minus 46 candidates based upon their merit. Full stop. The state would also be at liberty to include the 202 vacancies in the special drive for recruitment as directed by Honorable Division Bench of this court in writ petition into bracket PL bracket over number 46 of 2023. Full stop. The above the direction with regard to the petitioners shall be complied with within a period of 4 weeks, 6 weeks, 8 weeks, 8 weeks from today. Full stop. With the above directions, the petition stands disposed of as
Our
allowed.
appointments would relate back to 21. Since those days our vacancies are kept vacant by court's order.
Yes,
Sorry, my lord.
yes.
Those who were appointed in that recruitment process, our
Yes.
appointment shall be
Let me see the
effective
order
from
date
that day.
15/7/2000.
Very well. Learned Advocate General, would you have order dated 15/7/21?
Sir, are you-
Apna sir.
page 11
CM আছে
એની પછી વારિયા સાહેબ.
So it is at page 13 of the civil application, Mr. Advocate.
In my CA, it is at page 10.
This is the one, sir.
15 July 2020.
Yes, yes, yes.
There is then second day.
Prima facie, the contention of the petitioners regarding reservation of 3/4 seats in recruitment process has been accepted by the decision of division bench of this court, as no provision is made for reservation of physically handicapped candidates. The present formula is arrived at.
Therefore, we came
And
out
in
with a
my-
proposal before the learned division bench.
Right.
We have determined the vacancies right from 1995.
Right,
Now, supposing, in each and every case, we have to effect the appointment like that,
right.
the person will be getting this, the appointment without perform any work.
No, but then
Sir.
it will have to relate back, at least for the petitioners, Mr. Advocate General.
Yes.
They have been standing in the queue since 2021. This order was there
So
since.
that PI was with reference to the people standing in queue right from 1995.
True. So therefore, you are coming out with a special recruitment drive. There, nobody had been selected. Here, these people have participated in the appointment. They are entitled for appointment. 2021, what was the learned coordinator?
Policy at
Yes.
we had selected 9 people below who were below in this category, falling within the meritorious below.
Right. But once a central act is there, was it open for you to say that no, we will not comply with
That
that?
issue be kept open, we'll argue out.
Right.
Whether we
So
should
therefore,
relate back from 2021,
Yes.
should he get all the benefits?
no, he may not get the benefit, but he should at least be entitled for notional benefits. Fine, he has not worked. That is all right. But should he not get notional benefits?
So that's another aspect.
Right.
I thought my friends are pressing.
No, no, even
service
if
that
they,
we should be.
naturally,
Even if
they,
you
as the,
press,
for
don't be
petitioners,
first.
the
Then you
petitioners,
must
they
get
would be
also.
pressing for
You must
everything.
press and I must oppose. As simple as that.
That's right.
Right,
Ah,
right.
That doesn't mean it should be
So,
accepted
so
as the
therefore,
gospel.
therefore we said notional. We
So
go
you
by
need
no.
the notional.
I am saying he will say whatever. I am saying notional. Let it be from 21 with notional effect. Along with people, you may consider appointing, giving him an
Right,
appointment.
he is below all those people who were below standing in queue right from 1995
Mhm.
came out with a generous proposal before the elected bench.
Mhm.
So it's to see that we fall in line.
You're right.
We
But
will
they
we
never,
made a Herculean task to will not compute the polls.
sir,
We
got
did.
it. Got it. But they never had any right crystallized in their favor because they were never selected. Here we are looking at a category of persons who are selected or entitled to be selected.
Were not selected, Vinod. Though they were falling within their selection zone, Vinod.
Mhm.
In fact, we were Vinod, complying with only 3% reservation,
Right.
despite the fact that there was 4%
So
reservation.
here we are going by notional. You don't have to give them arrears, treat them as
This will create a precedent.
right.
My anxiety is this.
It may be recorded, it may not be
We
created.
have not tried to announce not less than 10,000 posts for this.
Right, but then what would be the burden when it's notional? He will be at the most getting the salary. Yes.
Pension will not. They will be.
One doubt.
Then
Then it would when they are persons with
the question of these people will not. The cumulative burden will be on a higher side.
true, but then when we are talking about persons with disability, if pension for or qualifying service for 3 years is taken, what difference will it make for the state?
This case it may not make a difference.
Not in any
But
case.
This principle
1,500 posts, Mr. Advocate General, for state of Gujarat, notional is not a
more than 10,000 posts.
no 1,500 posts. That is what
No.
you have said.
To begin with,
Right.
ultimately the undertaking which we gave before the division bench is more than 10,000 posts.
But then the division bench has not said anything about.
This was press in service.
Right. So division bench.
Say this they are doing now. You forget about the past.
Perfect. So then you will not be burdened with those 10,000. You are looking at 46 years.
That will perhaps on the strength of this order, they will come forward. We should also be given right from 95, 97, 98.
They have not
There will
come
be
to the
a
court. We have
cascading effect, Lord.
Very well. I'll say that. Then I'll not dispose it off. With regard to this, I'll keep it open. It may be argued someday. That will be too fine. Insofar as the submissions made on behalf of the petitioners as regards granting the petitioners notional benefits with effect from the year 2021 or thereabouts, when persons in the same selection process had been appointed, the issue is left open to be decided at the stage of final hearing. Yes.
please.
Agarma issue rule karina kare dega. Let this post for final hearing. Yes, please.
Lord.
Yes, please.
Yes.
Director of the
Yes,
candidate.
please. Yes.
Ron Mahina kayo? Within 3 months.
Rule. That's it.
This rule is already there.
Rule is already there.
Yes.
Fine. So then final hearing.
While passing order of
This
interim
is final hearing. That's all right. Fine. Simplicity.
This may a direct service be kindly granted.
That is 8 weeks. We have said 8 weeks. 8 weeks. 12. 8 weeks. Fine.
So
All right.
one more request, Mr. says this is an interim order and the petition would be pending before this court. And it's my humble request to the court that for the purpose of compliance only, this may be given a specific date and thereafter the rest of the issues that may be.
Very well. That's right. Rule returnable on the 10th of November for compliance. The later part with regard to entitlement for notional benefits would be decided at the stage of final hearing.
Lordship.
Right.
Great,
Yes,
Please.
yes, yes.
Mr. Pratik S. Patia.
Yes.
Silver 47, the Honorable Court indicated that it will take up together.
47?
40, because the matter wherein 2019.
Yes,
the salary is not paid.
yes.
And my learned period is also there.
Yes. So, Miss Sarda, what about 3? No.